Hi friends, in this video we are going to deal with the article titled Fundamental Rights, Right to Freedom, Article 19. The author of the article is one Miss Venika Sharma, who after completing her BA/BL is pursuing LLM from Jamia Millia Islamia, New Delhi. To know more about it, let's quickly move on to the topic.
Hello everyone, in this session I will elaborately discuss about Article 19. So let's start with the discussion. Article 19. So let's start with a brief history first. So the prime objective of people before 1947 was freedom. We received this freedom in 1947, but previously this non-communication became the main reason of our defeat in 1857 revolt. The reason basically was that there was no communication among people and it took very long to deliver messages from one person to another. The prime objective of the Constituent Assembly was to make this freedom felt by every Indian. That is why state expressly provided these rights. They did not exist per se and have to be conferred upon the citizens specifically. This is what differentiates between the citizens and the non-citizens. Article 19, Clause 1 confers 7 fundamental freedoms. Number 1 is freedom of speech and expression. Number 2, freedom of assembly. Number 3, freedom of association. Number 4, freedom of movement. Number 5, freedom of residence. Number 6 is right to property. Number 7 goes with freedom of trade and occupation. Now, in 1978, by the 44th Constitutional Amendment, this is a very important constitutional amendment because the right to property was deleted from the ambit of fundamental rights, that is, it was omitted from both Article 31 as well as Article 19, Clause 1, Subclause F. Originally, Article 19 provided for 7 fundamental freedoms to the citizens of India in 1950. But at present, there are only 6 fundamental rights under Article 19 as Subclause F of Article 19, which provided us the right related to property. It was deleted from the list of fundamental freedoms in 1978 by 44th Constitutional Amendment. Article 19, Clause 1, Subclause A talks about freedom of speech and expression. The word freedom is used in Article 19, Clause 1, Subclause A because its interpretation is very broad and not just confined to speech and expression. There is a landmark case of Dharam Dutt versus Union of India. It is a 2004 Supreme Court judgment. The Honorable Supreme Court held that the use of word freedom in Article 19 in itself suggests that the intention is to give a wide application to the speech and expression as compared to the other rights under the other clauses of this article. It would always be read subject to restrictions that are mentioned under Article 19, Subclause 2. Now, freedom of press is included in the ambit of Clause 1, Subclause A of Article 19, and Dr. Bhimrao Ambedkar said that press has no special rights which are not to be given or which are not to be exercised by the citizens in his individual capacity. The editor of the press or the manager are merely exercising the right of expression and therefore no special mention is necessary for the freedom of press. Now, there was one more case, very important case. In the case of Sakal Papers Private Limited versus Union of India, it is a 1962 Supreme Court judgment. The content and page numbers of the newspaper were fixed by a law made by the government. The Honorable Supreme Court held that the order affected the circulation as to the plea of the state justifying the legislation as a restriction on the business activity under Article 19, Clause 6. It held that only restriction which may be imposed on the press are those which Clause 2 of Article 19 permits and no other restrictions can be imposed. The right of freedom of speech cannot be taken away by the subject of placing by the object of placing restriction on the business activity of the citizens. In another very famous case of Bennett Coleman versus Union of India, 1973 Supreme Court judgment, the Apex Court held that the freedom is not only in the volume of circulation but also in the volume of news and views. The press has the right to free propagation without previous restraint. If a law was to single out the press for laying out prohibition burdens, on it and would restrict to the circulation. This would violate Article 19, Clause 1, Subclause A and would fall outside the protection of Article 19, Subclause 2. In another case of Brij Bhushan versus State of Delhi, 1950 judgment, the order directing the editor and the publisher of the newspaper to submit for scrutiny before publication all communal matters, all news and views about Pakistan, including cartoons and photographs, was struck down by the Supreme Court as the imposition of pre-censorship on the journal is the restriction upon the surety of press. Now, next is a very important case of Muhammad Ajmal Amir Kasab versus State of Maharashtra, 2012 Supreme Court. The freedom of expression is not an absolute right and subject to reasonable restriction. An action tending to violate other person's right to life or putting the national security in jeopardy can never be justified by taking the plea of freedom of speech and expression. Commercial advertisements is also included in the ambit of Article 19, Clause 1, Subclause A. A newspaper can be segregated into two parts. First is speech, which includes both news and views of people, and second is the non-speech, that is commercial advertisement, which includes pictures, commercials, etc. In the case of Hamdard Davakhana versus Union of India 1960, the Honorable Supreme Court held that commercial advertisement has an element of trade and commerce and it no longer falls within the freedom of speech and expression as its object is not to propagate ideas, social, political or economic. Indian Express newspaper versus Union of India 1985 is also a very important case. The Honorable Supreme Court held that all commercial advertisements cannot be denied to be conveyed under Article 19, Clause 1, Subclause A, merely because they are issued by the businessman. Next case we have is of Tata Press Limited versus MTNL 1995 Supreme Court. The commercial speech it was held that the commercial speech is a part of freedom of speech and expression under Article 19, Clause 1, Subclause A. It protects the right of an individual to listen, read and receive commercial speech. The protection is available to both the publisher and the recipient of speech. Now there is one more important case, the case of 2004. It is of Naveen Jindal versus Union of India. In this case, it was held that right to hoist a national flag freely with respect and dignity is included under Article 19, Clause 1, Subclause A. Next is the right to strike. Now there are two things. First is going on strike and the second is threat to go on a strike. The first one, that is the right to strike, is not covered under Article 19. The only thing that Article 19 covers is the right to threat to go on the strike under Article 19, Clause 1, Subclause A. There was a case, Ramlila Maidan, or the Ramlila Maidan case of 2012. It is covered in this, the strike part of Article 19, and it was held by Honorable Supreme Court that threat to go on a hunger strike is also protected under the Article 19, 1A. In this case of Harish Uppal versus Union of India 2003 Supreme Court judgment, it was held that lawyers do not have the right to go on strike or given a call for boycott. Now, the next very famous case is of PUCL versus Union of India 1997 Supreme Court, which is also known as the phone tapping case. It is very famously known as a phone tapping case. It was held that when a person is talking on a telephone, he is exercising his right of freedom of speech and expression. So, tapping of phones infringes Article 19 1A unless it falls within the ground of Article 19 Clause 2. So, right to freedom of speech and expression is not an absolute right and it is subject to certain restrictions, and as these restrictions are mentioned under Clause 2. As per Clause 2 of Article 19, restrictions can be imposed upon the freedom of speech and expression in the interest of, there are 7 grounds. So I'll tell them one by one. The first is sovereignty and integrity of India. The second is the security of the state. The third is the friendly relations with the foreign state. Fourth is the public order, decency and morality. Fifth is in relation to contempt of court. Sixth is defamation, and seventh is incitement to an offense. So if any of these grounds exist, you can infringe the right. Now let's move to the next freedom, that is freedom of assembly. The Constitution guarantees right to hold meetings and take out processions. The processions and meetings should be unarmed and peaceful. This right may be restricted in the interest of public order or sovereignty and integrity of the country. Clause 3 of Article 19 provides for the restrictions that can be imposed on the right to freedom of assembly. They are as follows. Number 1, if it is in the interest of sovereignty and integrity of the nation, the restrictions can be imposed. And second is if it is in the interest of public order, then these restrictions can be imposed. Now, subclause C of clause 1 of Article 19, it talks about freedom of association. The Constitution declares that all citizens will have the right to form associations and unions. In the landmark case of T.K. Rangarajan versus State of Tamil Nadu, it was held that right to form association does not carry the right to strike. According to clause 4 of Article 19, reasonable restrictions can be imposed on the right to form associations, unions and cooperative societies, etc. on the following grounds. Number 1 being as stated earlier, sovereignty and integrity of India, and number 2 is on the basis of public order and morality. Now next subclause, it deals with the freedom of movement which is guaranteed by the Constitution, and the citizens can move from one state to another and anywhere within a state. A person free to move from any point or any point to any point within the country territories. As per clause 5 of Article 19, the right to freedom of movement and residence could be restricted on the following grounds. Number 1 is if it is in the interest of a general public, and number 2 for the protection of the interest of the scheduled tribes. In the landmark case relating to it is Khadak Singh versus State of UP, in which it was held that watching and shadowing the suspects for the purpose of keeping record of their movement and activities. Next is the freedom of residence. An Indian citizen is free to reside in any state. Again, this is subject to certain restrictions. The last subclause, that is subclause G of clause 1 of Article 19, is freedom of trade and occupation. The Constitution of India guarantees each of its citizens to do trade, occupation or business anywhere in the country. And thus, in the landmark case of P.A. Inamdar versus State of Maharashtra, it was held that education is an occupation. Also, the fundamental rights under this clause can be restricted in the following ways. Number 1 being imposing reasonable restrictions in the interest of the general public, and number 2 by state monopoly. So I hope that is for today, and I hope you find this session helpful. Thank you.